Luke. It's really great to be here. What a privilege to be here at the Tax Justice Network conference, but also with such a distinguished group of panelists. I get to be our moderator, which is a lot of fun for me. So the topic today is journalism and whistleblowing, and a really heady title, Serving the Public Interest in Representative Democracy. So I do believe that whistleblowers and journalists are sort of the front line for us in, or the first line of defense and the last line of defense against corruption and fraud. So it's with great privilege that I introduce you to a distinguished panel of individuals who cross the journalism and whistleblowing spectrum. So I'd first like to introduce you to Susan Cawtrey. Susan's the project director at the Foreign Policy Center in the UK. She's leading the Foreign Policy Center's project Unsafe Scrutiny, how journalists around the world investigating financial crimes in the UK jurisdictions face risk to their freedom and security from vexatious lawsuits and to violence. So she will be our definitive source to talk about the risks that journalists face and undertake in speaking and exposing corruption. We will then turn to Khadijah Sharif, who we're hoping will be joining us, might be a little bit late. She crosses both spectrums of the journalism and the whistleblower sphere. She is the African editor at OCCRP, the Organized Crime and Corruption Reporting Project. Before that, she was the director at PLOF, which is called the Platform for Protection of African Whistleblowers, which is a nonprofit William Bourdon set up that seeks to protect whistleblowers throughout Africa. So she bridges both of those topics. From there, I will be pleased to introduce you to Joshua Dugan. Josh comes to us from New York. He's in the New York Attorney General's office as an assistant attorney general. He'll be speaking to us today about the whistleblower reward program that the New York AG's office has. He is particularly relevant because he just secured the largest state income tax settlement under the New York False Claims Act, $105 million collected. And it was against a hedge fund billionaire by the name of Thomas Sandell. So he'll be talking to us about a specific whistleblower case, how a whistleblower helped bring the information to the AG's office to help them prosecute Sandell. And last but not least, we will have Osita Mba. Osita is a barrister solicitor in Nigeria. He's also the solicitor advocate in England and Wales. He works at Tax Watch. Before that, he worked for 7 years at HMRC as a solicitor. And he himself, in addition to being an expert on tax law, he also himself is a tax whistleblower. He exposed a tax settlement between HMRC and Goldman Sachs, where Goldman was let off from paying $10 million in interest by the head of HMRC's tax policy. So without any further ado, I'm going to turn it over to Susan to kick us off on the role of journalists in exposing corruption.
Thank you very much, Mary. And I'm also very glad to be here with such a great group of people. So just to explain, the Foreign Policy Centre is an international affairs think tank. And since last July, we've been running a research project called Unsafe Scrutiny. And it basically examines issues at the nexus of safety of journalists and anti-corruption with a particular focus on the UK. As I'm sure we are all aware in this group, there's been, in recent years, successive transnational investigations led by amazing groups of journalists all over the world exposing financial crime and corruption, facilitated at least in part by UK legal financial systems, as well as of those in other jurisdictions. While the fallout of these investigations has had a very positive impact around the world, there's been changes to financial regulation, arrests and imprisonment of wrongdoers, as well as the recovery of billions of illicit funds and fines. It's unfortunately journalists who've faced very negative repercussions. The most serious of this, of course, is the murder of investigative journalists, of which I'm going to speak about two. The Maltese investigative journalist Daphne Caruana Galizia, who was murdered by a car bomb outside her home in October 2017. Over the course of the year prior to her murder, she had posted several allegations about corruption amongst her country's political elite, linked to revelations that had sort of stemmed from the Panama Papers. And in the intervening years since her death, as many people maybe have been following what's been happening in Malta, it's all been unraveling, and a lot of what she was writing about has been proven true. A few months after her death, very sadly, in February 2018, the Slovak investigative journalist Jan Kuciak and his fiancée, who were both only 27, were shot dead near their home. Kuciak worked for the news website Actuality, and he covered issues ranging from tax fraud amongst Slovak businessmen with political ties to the potential embezzlement of EU funds in the country. Of course, like, murder and physical attack are the most extreme violations against any journalist, but it's very rarely the starting point. In my previous role at Article 19, which is an international freedom of expression organization, I worked on safety of journalist issues and on many cases of journalists facing violations around the world. One of those was the case of Khadijah Ismailova, who's an independent journalist in Azerbaijan. She had uncovered high-level corruption amongst her country's political elites, and her reporting contributed to OCCRP's Azerbaijan laundromat, which revealed a complex money laundering scheme which handled something like 2.9 billion over a 2-year period through 4 shell companies registered in the UK. It was that 2-year period between 2012 and 2014, which was actually a time of severe crackdown on human rights inside of the country. Members of Azerbaijan's political elite, according to the reporting, were using these funds to pay off European politicians and buy luxury goods and otherwise benefit themselves. Meanwhile, Khadijah Ismailova, in the last decade, has been subject to harassment, multiple arrests, and really, truly horrific smear campaigns. She was arrested and sentenced in 2015 to 7.5 years in prison on charges of embezzlement and tax evasion, sort of rather ironically. She was released from prison in 2016, but her conviction was not overturned, and a travel ban that she was subject to since then was only lifted a couple of months ago. So she's been locked inside of the country for several years. There was a European Court of Human Rights ruling in her favour in February 2020, and it found that there was no reasonable suspicion that she committed the crimes that she was accused of, and it was rather an attempt to silence her journalism. So to better understand the risks and threats facing journalists, when we started this project a year ago, we decided to conduct a survey, which we did with the support of OCCRP and other global networks. We had responses from 63 investigative journalists working on financial crime and corruption in 41 countries. The majority of them, 71%, reported experiencing threats and harassment. In particular, there was incidences of verbal and written threats, online trolling, surveillance, both on and offline, that were happening with worrying regularity, very frequently. And there was only a very small percentage of respondents, 6%, who felt completely safe conducting their work. I think, however, the most concerning findings for us was the level to which respondents were receiving legal threats. 73% of all the respondents had been subject to some form of legal threat. And most shockingly of all, especially for someone who's based here, the UK was the leading source of those threats, almost as high as the legal threats stemming from EU countries and the US combined. Half of the respondents reported to us that it was these legal threats that posed the greatest challenge in their ability to continue working. So to follow up on that survey, which we published last November, we also produced a report in December called Unsafe Scrutiny, which examined in more detail specific cases. These included the case of Paul Radu, who's the Romanian co-founder of OCCRP, which is registered in the US. And he was pursued for almost 2 years through the UK courts by a sitting Azerbaijani MP. In the end, right on the eve of the trial in January last year, the MP decided to withdraw the case and settle in terms that were favourable to Radu. The articles under claim did stay online, albeit with a disclaimer, and there were costs reimbursed. But this was hardly a kind of resounding victory. There'd been a huge drain for 2 years on their resources, and financial and human, because it directed away from the investigative work that they were doing. It was a very similar story to that of Claire Rewcastle-Brown, who's an independent British journalist uncovering the 1MDB corruption scandal in Malaysia. Similarly, for 2 years between 2017 and 2019, she was pursued through the UK courts by a Malaysian politician before the case was ultimately withdrawn and settled in her favour, or favourably to her. She's continued to be the subject of legal threats despite her reporting on 1MDB, contributing to the collapse of the former Malaysian government and the former Prime Minister now being in jail. And there are other ongoing cases that we are keeping track of, including a current case with a Swedish business publication called Realtid, which is currently being sued in the UK despite being in Swedish language, and the person who's suing is a Swedish businessman based in Monaco. So there's a lot of concern about how the UK system is being used, but actually legal cases don't even need to reach court to have a significant impact. Another case we looked at was that of Dan McCrum. He's a financial journalist who, during the course of his 5-year investigation into Wirecard, which was a German financial technology firm, he described being subject to furious online abuse, hacking, electronic eavesdropping, physical surveillance, and some of London's most expensive lawyers. He particularly noted when describing his experiences that while observers of the Wirecard scandal have criticised the German establishment for the fact that it ran on for so long, it was actually all the external professionals hired by the company to protect its reputation that were based in London. So as we've been continuing our research, we found stories like this are actually effectively the tip of the iceberg. And every time a journalist does speak out, and I'm pleased to say more are increasingly feeling comfortable to do so, it is possible to kind of get a glimpse at the extent of the hidden problem. Journalists don't generally want to talk about legal threats against them, and particularly if they have been successful, because they don't want to obviously admit that they have been, or they have capitulated to legal intimidation. This type of threat, however, is increasingly getting recognition and being referred to as SLAPS, strategic litigation against public participation. It's a topic that has been discussed in the US, I think, with a much longer history, and obviously not just with journalists, but it's become sort of to increase prominence in Europe after the murder of Daphne Caruana Galizia. She had up to 40 cases open against her at the time of her death. They're certainly seen as actions that are taken not with winning in court, and slightly belied by the fact that people keep settling, but instead aim to intimidate, to induce fear, to tire and consume the financial and psychological resources of the target. Basically, the aim is to limit the spread of information, and it's clearly having a chilling effect. These legal threats come mostly with letters marked private and confidential, and if successful, it creates a vacuum of information. The public won't know what the journalist was writing about, or even that a legal challenge took place. The removal of this information certainly impacts wrongdoing. The removal of information about those accused of wrongdoing certainly impacts due diligence, anti-money laundering processes, and it makes it harder for law enforcement to gather information and leads. I think we could say it's not surprising that countries with higher rates of corruption also tend to have fewer protections for journalists in the media, but it is concerning that legal systems like the ones in the UK and other countries in Europe are being misused in this way. In November last year, Dunja Mijatovic, who's the Council of Europe's Commissioner for Human Rights, said about SLAPS that they pose a significant and growing threat to the right to freedom of expression, and they pervert the justice system and the rule of law more generally. There's actually been a huge kind of shift in the last year and effort by a number of civil society organizations on this topic across Europe through a coalition called CASE, the Coalition Against SLAPS in Europe. And they've been pushing for an anti-SLAP directive at an EU level. Unfortunately, the UK post-Brexit falls out of that, but FPC, together with Index on Censorship and a number of other organisations concerned on this topic, have formed a similar working group in the UK and will be publishing a policy paper outlining some ideas of how to start redressing this issue next week. So I hope to share that with you after this. I think certainly we feel that if societies, we believe in protecting journalists, we really need to look at this topic more carefully. Investigative journalists have repeatedly demonstrated their critical role in investigating crime and corruption, and it's the first step, obviously, for ensuring accountability and redress. But if that role is threatened, journalists themselves are unable to continue to bring matters of important public interest to light. So any attacks against them, whether it's journalists or whistleblowers, activists, all part of this public interest ecosystem, violations need to be seen not just as individual attacks, but attacks on society as a whole. So I'll leave it there. Thank you very much.
Thank you, Susan. I really appreciate your last comments because the parallelism between whistleblowers and journalists is very obvious. And interestingly, the new EU Whistleblowing Directive, which is going to be a sea change for whistleblower protection across all 27 member states. Previously, only 8 had the protections. Now it will be basically a quilt. But interestingly, they expand the definition of a whistleblower to include journalists. I mean, we just wrote a paper for the Association of European Journalists to explain that it's pretty clear that the knock-on effects that impact whistleblowers equally impact the journalists that they give their information to. So it's a little bit of a hopeful sign in terms of recognition that the protections that whistleblowers get should go to their journalists as well. Interestingly, also, when you're talking about the criminalization of journalists, we've seen similar actions against whistleblowers. Most prominently today, there's been a UK whistleblower, Jonathan Taylor, who helped expose bribery in the oil and gas industry, was held in Croatia for over 300 days, was going to be extradited to Monaco, where his former employer had outsized influence and basically had tried to hold him for a criminal claim of extortion, even though he'd been fully corroborated. He was actually, the UK government interceded, and he is coming home today. So just wanted to say that happy note, but that whistleblowers and journalists are often face criminal sanctions, but also the legal sanctions you were talking about in terms of legal threats, the chilling effect of legal actions against journalists, similarly to whistleblowers. One of our clients is Tyler Schultz, who famously was the Theranos whistleblower, and he incurred over $400,000 in legal fees defending against what was portrayed as a breach of his confidentiality agreement and the proprietary information of Theranos. He famously said fraud is not a trade secret. So we now have trade secret laws that allow whistleblowers to bring that information to the government or an enforcement agency and not be prosecuted for a breach. But we have a long way to go, but I just wanted to tell you we're simpatico. Whistleblowers and journalists face the same problems, which is why I'm glad we're on this panel today. So switching gears a little bit, I want to turn it over to Joshua Dugan. Josh is going to, as we said, is going to talk a little bit about how whistleblowers in the United States are financially rewarded for bringing information forward about tax law violations. His statute is incredibly unique, and people, I think, are familiar with our IRS program, which is a tip program. Whistleblowers lob in a tip, and if the IRS imposes a fine, they get a percentage. Under Josh's program, which is the New York False Claims Act, the whistleblower is actually empowered to launch a lawsuit in the name of the state of New York and proceed sort of like a private prosecutor. And so he's going to tell you about how those whistleblowers help his office to prosecute tax fraud.
Great, thank you. Thank you so much, Mary. Good morning, good afternoon. Very, very glad to be here today to be part of this important discussion. Just a quick note before I get started, any views or opinions expressed by me here today are my own. They are not a reflection of office policy and should not be attributed to the office or to the New York Attorney General. But so with that in mind, as Mary said, I'm going to speak a little bit today, kind of very briefly about the work that the Bureau I work in does, particularly the work that it does with whistleblowers and their counsel to combat fraud, particularly in the tax arena. Then I'm going to talk a little bit about a case that we recently settled that I think gives a sort of good overview of the work we do and how whistleblowers really contribute in this important area, and then walk through what I think are some of the key takeaways from that case. So as Mary mentioned, I'm an Assistant Attorney General in the Taxpayer Protection Bureau of the New York Attorney General's Office. And what that bureau does, as Mary said, was enforce an anti-fraud statute in New York called the New York False Claims Act. What the New York False Claims Act does is it provides a mechanism for whistleblowers, also known as relators, to bring forth allegations of fraud, which are then investigated by the government. And if the government obtains a recovery in those matters, either through a judgment after trial or through a settlement with the defendants, the whistleblower is entitled to a share of that recovery. And typically, the share of the recovery that the whistleblower is entitled to is on the order of 15 to 25%, with some exceptions, but that's the general rule. As I'm sure many of you know, the federal government and many other jurisdictions in the United States have their own version of the False Claims Act. But what makes the New York statute relatively unique, albeit less so in very recent months, is that it allows the False Claims Act to be used to investigate and prosecute knowing violations of different types of the tax law. So it becomes an enforcement tool against tax fraud and against tax evasion. Since the legislature expanded the New York False Claims Act to allow for whistleblowers to bring forth allegations of fraud under the tax law, that was in 2010, we have recovered roughly $580 million, a little bit more than that, from entities and individuals for tax evasion. And of that, and that's just the tax evasion part, that's not other parts of fraud, other types of fraud alleged under or prosecuted under the False Claims Act. And of that 580 or so million, over $100 million of that has gone to reward whistleblowers for their substantial assistance in these matters. So as I mentioned, and as Mary mentioned, the case I want to talk to you about today is a case we settled in February involving a hedge fund manager named Thomas Sandell. And what happened there was we received a whistleblower complaint towards the end of 2018, which alleged that Mr. Sandell and his hedge fund had avoided New York State and New York City taxes on about $450 million in deferred income. And what happened there was, according to the allegations of the whistleblower, who I should note, whose identity remains confidential, according to the complaint, Mr. Sandell and his organization earned this $450 million or so during a 10-year period exclusively in New York. And there is a provision of the New York tax law and a corresponding provision in the city administrative code that makes clear that if you earn money from services performed in New York, you owe taxes, you owe New York taxes on that money, regardless of where you are, where the person or the entity is when the money is ultimately recognized for federal tax purposes. And so in this case, the $450 million was recognized for federal tax purposes in 2017. And in 2017, Mr. Sandell had moved to London, and he claimed that his organization had left New York and moved to Florida. But based on the allegations and the evidence that we received from the whistleblower, it turned out that Mr. Sandell and his organization had only set up a shell office in Florida that had 3 back office non-revenue generating employees, and that all of his other operations remained effectively the same as they had always been in New York. And in addition to the shell office, Mr. Sandell had also moved responsibility for actually paying his employees and rent to a related company that he also owned in order to be able to claim that he didn't have any employees or offices in New York, when in fact he did. The whistleblower was also able to allege and point us to specific evidence that when it came time to file his tax returns, Mr. Sandell's longtime tax preparer, along with several other advisors, had told him that the position he wanted to take, that is, that he did not owe any New York taxes, was contrary to law, and that indeed his longtime tax preparer told him that he would not sign a tax return that reflected 0 in taxes owed to New York State or New York City. The same tax preparer also told Mr. Sandell, we learned from the whistleblower, that if he really was insistent on taking a position that he owed no New York taxes, he would need to find an accounting firm that was willing to give him an opinion substantiating that position. Mr. Sandell was ultimately able to find an accounting firm that was willing to take that position, but that accounting firm did not provide him with an opinion or any sort of explanation supporting that position in the end. So based on the allegations from the whistleblower, our office spent about 18 months actually investigating the claims alleged in the whistleblower's complaint. And then some period of time that was delayed because of the pandemic, reaching a resolution. We ultimately, as I said, announced a resolution in February for $105 million, which, as Mary said, is the largest income tax settlement under the False Claims Act in the United States. And that amount included not only the full amount of taxes that were owed plus interest, but also substantial damages for the fraud that was committed. And of that $105 million, 21% of it, or a little bit over 22 million, went to the whistleblower, which really reflects the whistleblower's substantial work here. So a couple of things that I think are worth focusing on in terms of takeaways. So the first is really the incredible work and the incredible importance of whistleblowers and their counsel in these types of matters, particularly when you're talking about tax fraud. So here we had a very sophisticated person and entity who had tax returns prepared and signed by a major accounting firm. It would have been incredibly difficult under those circumstances to find evidence of fraud, but for a whistleblower who was able to come in and point us to specific evidence and be able to lay out essentially a roadmap for us to be able to find the evidence of fraud. When I've been thinking about what whistleblowers and their counsel really do in terms of an investigation, I have young children, and I sort of see everything through their eyes at times. And I think about the puzzles that they do. I'm thinking about a dinosaur puzzle that has the shapes, you pull out the pieces, but it still has the shapes of the dinosaur and it has everything there, as opposed to adult puzzles where you're sort of left figuring out where all the pieces go on your own. And I think that's really a good way of thinking about what whistleblowers and their counsel do. The whistleblower gives you an outline. We as the government still need to find the pieces and still need to be sure how they connect, but the whistleblower really provides the outline and lets you know where they go. And in the same vein, the whistleblower's counsel, it sort of explains how the pieces fit together, explains, the legal story, avoids, whereas a whistleblower who doesn't have legal training might focus on sort of the more salacious or scandalous parts of a story. A whistleblower's counsel really can help distill for the government how the pieces, the facts of the whistleblower's story fit into a legal narrative that'll help build a case. So incredibly important work there. The second takeaway, I think that's important to see here is that tax law can really be unambiguous. It can be clear. I think there's this notion at times where all of us think, or not where all of us think, but where many people can think, oh, it's taxes, it's incredibly complicated. Who knows if there's a right answer? And I think this case really illustrates well how oftentimes that's not the case. Sometimes there really is a clear answer in the tax law, just like any other law. We work hand in glove in this case and in all cases with the New York tax authorities here to make sure that our view of the law and their view of the law were aligned, that there really is, and was in this case, no reasonable basis to take a contrary position here. A related point, I think along those lines, is that you can commit fraud in the tax context just like you can commit fraud anywhere else. In this case, we had, some of the key indicia of fraud that you would see in any context. We had concealment, someone who tried to hide the location of his business through using related entities, through shell offices. Part of the way that we were able to tell that his office wasn't really in Florida was because he conceded or acknowledged to the SEC during an SEC audit that his principal operations were in New York, even while he was maintaining to the New York tax authorities that all of his business operations were being conducted out of Florida. In the same way, we have pretty clear example here where a person taking a position was on notice that that position was contrary to law from experts and advisors here. That same type of evidence, I think, is the same type of fraud or the same type of indicia of fraud that one might expect to find or see in any other context. And again, sort of related to the point about advisors here, this was a case where the taxpayer and the defendant found an advisor at the end of the day to sign off on his position. I think, what we hope this case shows is that simply finding someone to sign off on a position doesn't mean that that position's right, and it doesn't mean that that position is going to be immunized from scrutiny. Taxpayers or defendants who find an expert to sign off on a tax position without adequate due diligence, without establishing a legal basis, and without documenting the legal basis for that position, could still find themselves in legal jeopardy, particularly where the defendant is on notice from another advisor or another expert that that position could be contrary to law. And finally, just to bring it back to whistleblowers here, I mentioned the 21% of the recovery that the whistleblower received here, $22 million. I think it's important to note that that recognizes the work that the whistleblower did, how much more efficient and how much more quickly our investigation was able to proceed because of the whistleblower's help. But it's also a recognition of the serious risks, both professionally and personally, that whistleblowers take, and the need to reward and incentivize whistleblowers to take those risks in this context. As I noted, the whistleblower's identity remains confidential. That's something that is very important to our office. It's not something that we can guarantee in every context, particularly if cases go on to more advanced stages of litigation. But it's something that we recognize is incredibly important and something we will protect whenever we can. So to conclude, I hope the Sandell case and I hope this discussion illustrates that the whistleblower program that we have in New York has been incredibly successful. We think it has served an incredible public interest in rooting out fraud and corruption. And our hope and expectation is that that work will continue and that the New York False Claims Act and the whistleblower provisions of the False Claims Act will really continue to be an important tool for protecting the public interest going forward.
Thank you so much, Josh. That was really, really great. One thing I think I may have said at the top, but it bears repeating. There is peer pressure that goes on in the United States where if you're Sandell, you could be avoiding federal taxes and state taxes at the same time. There's often a parallel federal IRS whistleblower investigation and a state one. And the state of New York will often be much faster and more aggressive in reaching a resolution, which actually then in turn puts pressure on the IRS to do something. So we're very fond of the New York AG's office and their stance. They are definitely a leader. I think Josh was alluding to the fact that the District of Columbia just amended its False Claims Act to allow tax fraud to be prosecuted. They certainly don't have the same track record that the New York AG's office does. So I'm now going to turn it over to Osita Mba. And what's interesting here is we're segueing from a position where several countries, the United States, Canada, South Korea, have mandatory programs where they pay whistleblowers for tax fraud. But in the United States, we're kind of hypocritical. We have whistleblower rewards when it's fraud against the government, but when it's fraud by the government, we don't reward whistleblowers. So Osita here has exposed HMRC. He would be in the United States what we call a government whistleblower. And sadly, we've been pushing for, but there are no reward programs. And I think that is an oversight and a lapse that we have. HMRC does have a fraud hotline with a discretionary reward program, but the data that we've seen is they don't advertise the program, and when we did an FOI request, they tend to pay out about 400,000 pounds a year. So I want to turn it over to Osita to tell us about what it was like to be a government whistleblower, to be within HMRC and to expose wrongdoing there, and what we can learn from that. Thank you, Osita.
Thank you very much, Mary, and good afternoon, everybody. As Mary said, I'll talk about whistleblowing and also journalism. And there are two competing public interests we need to bear in mind here. The first one is taxpayer confidentiality, which is what Mary alluded to, which is the confidentiality of information taxpayers provide to tax authorities. The second is the transparency and accountability of tax administration, which is where whistleblowers and journalists come in, because if there is wrongdoing, including crime or corruption, whistleblowers are entitled to expose it, journalists are entitled to expose it, and the public are entitled to know about it. So how do we strike that balance? Now, when Mary talked about the US having a provision for exposing fraud by taxpayers, but not internal fraud by the tax authority, that what she was referring to is the principle of taxpayer confidentiality. So in all jurisdictions that I know of, it's a crime to disclose taxpayer information without authorization. So in the UK, it's a crime to do so, and the penalty can be up to 2 years imprisonment plus a fine. And any journalist that is involved in any way in that disclosure could be charged with conspiracy to commit the same offense and sentenced to the same imprisonment. And the important thing about this is that this is what is called an absolute offense. So the first point is that there is no damage or harm test. In other words, the prosecution does not need to prove that a disclosure caused any damage or harm. It's absolute. And then the second is that the defense is not allowed to prove that a disclosure was in the public interest. So the only thing that counts is that there was a disclosure. And if there was, there's an offense. So this raises the issue as to whether the crime of disclosing taxpayer information is proportionate and compatible with human rights legislation. So if we look at the right to freedom of expression in Article 19 of the Universal Declaration of Human Rights, in EU we have the European Convention on Human Rights. So that's in Article 10. So it provides quite clearly that the right to freedom of expression includes the right to receive and impart information without interference by the state, subject to very limited specified exceptions. So if you're looking at taxpayers' information, we're looking at the need to prevent the disclosure of information provided in confidence. So that would be the rationale in general to restrict the right to free speech in terms of taxpayer confidentiality. But if we look at Article 8 on the right to privacy itself under the convention, it's not an absolute right. It's actually qualified by several public interests. For example, the economic well-being of the country is a factor. The prevention of the commission of crime is a factor. And then the rights of others, in this case, the rights of whistleblowers and journalists, are a factor to take into account in limiting the right to privacy. So that's under the convention, which is civil law. But when it comes to the crime, it's an absolute offense to disclose taxpayer information. So there is clearly a mismatch between the criminal law and the civil law. So, and based on the jurisprudence of the European Court of Human Rights, it's quite clear to me that the strict liability, the crime of unauthorized disclosure will not stand up in court as being compatible with the right to freedom of expression. So to illustrate this, I'll talk about my case briefly and then we end by considering how we can make it better. So when I worked for HMRC, I worked in the personal tax litigation team. So we dealt with tax avoidance cases. And one of the cases was the case Mary referred to, which involved Goldman Sachs. This was a tax avoidance scheme that didn't work, as we say. So there are 14 companies that use the schemes. So HMRC offered them a deal after 7 years of litigation. So they will pay the tax, but not the interest that had accrued over 7 years. So 13 companies accepted the deal. So they didn't, Goldman Sachs refused, and they now fought the case for another 5 years. So Mary referred to £10 million as being interest. That was the interest in when the other 14 companies were offered a deal. By the time it was actually settled, it was 20 million. So what happened was that the chief executive of HMRC went to Goldman Sachs for other matters and decided to settle the case without including the interest of £20 million. He did not seek our advice. He did not inform anybody. So when he returned and informed us that he had settled the case, even though the document hadn't been signed, he was told that there's no reason why they shouldn't pay the £20 million interest. But he refused to go back to them to demand it. So my line manager was aware of this. He reported it to the head of legal, who was aware of this, but they both knew what the chief executive wanted, which was to complete the deal. So they gave him what he wanted. Now, there's an important background to this deal. So even though this was just £20 million at the time, there are 4 other big settlements the same official has struck in the same way. I can only tell you about the one that was in the public domain. So that was Vodafone. Again, the tax avoidance scheme, Vodafone fought the case. When they lost in court, they were given a deal. Now, so the deal they were given was to pay £1.25 billion, whereas Vodafone themselves had set aside £2.2 billion in their account. So they're actually giving a deal that was £1 billion less than what they had provided. Now, the lawyers working on the case believe that the actual amount they should pay will be anything up to £6 billion. So let's say, for the purpose of this discussion, that they are let off of £5 billion. Now, the other 4 deals, all I can say on that is that each of them, what was recovered was £1 billion average each. So if we say, for the purpose of this talk, that if Vodafone cost the taxpayer up to £5 billion, if you multiply that by 4, you'll be looking at potential loss to revenue of £20 billion. And of course, tax officials work under very strict rules in terms of how they can protect the public revenue. So there's a common law offense of cheating, which applies when you cause a loss to the tax authority. And then there's fraud by abuse of position under the Fraud Act. So my view of this is that these deals were not lawful, that they were criminal. They are something that required criminal investigation. But the difficulty is that because of the law on taxpayer confidentiality, there's no way you could disclose this outside the department. Internally, what I was allowed to do was to report it to my line manager, who of course knew about the Goldman Sachs one, and he will now report it to the head of legal, who knew about it all. And then the head of legal will then report it to the chief executive, who was the person that did the deal, and also the only person that had the authority at the time in HMRC to disclose information outside the department. He had the sole authority. Yet he was the same person that had done the deal. So clearly, he wasn't going to expose something that would implicate him even to the extent of being a crime. So there was no practicable or effective internal mechanism. But any external disclosure will be a crime. And so if I had gone to a journalist, I'll be committing a crime. And if the journalist reported it, they'll be committing a crime. So that was the situation I found myself in. But at the time, I had moved on to the information law team, so I knew a bit more about the internal mechanism. But what I knew for sure was that there was no legal way within the statute to disclose this outside the department. So I felt that what I could do in order to protect myself, because it was quite clear to me that it was in the public interest to disclose this, not just because of the amount involved, but because it was a crime that was committed, it required investigation. And clearly, this is something Parliament and the public need to know about. So I started to approach the Public Accounts Committee on the basis that if I disclose information to a parliamentary committee, HMRC and the Criminal Prosecution Service, the CPS, which are part of the executive, cannot prosecute somebody assisting a committee of parliament. So that was my defense, in the sense that if I disclose information to parliament, then there's nothing HMRC could do about it. Clearly, that's not where you want to be, but as a lawyer or as a whistleblower, but I felt that was what I had to do, and that's what I did. So that was how the matter became public and led to everything that came from that. And even then, the chief executive of HMRC that did the deal refused to answer any questions in Parliament because he had the power to decide what information HMRC disclosed to everybody, including Parliament. So you can see how difficult this situation is. So, in summary, what I feel this shows is that in order to protect whistleblowers, both HMRC and anybody that they disclose information to, and any journalist reporting such wrongdoing, there are at least two things that need to be done. And the reason they need to be done is to make sure that the law that criminalizes disclosing information is compatible with the right to freedom of expression. I think the first thing to do is to have a harm or damage test. In other words, the prosecution has to prove that the disclosure caused damage either to the taxpayer or to HMRC. For example, on the Vodafone case, it was Vodafone that disclosed that they had settled with HMRC for 1.2 billion. They had also disclosed that they set aside 2.2. So there's nothing secret. The only thing that wasn't in the public domain was the fact that they settled for less than they should. So what was the harm to them or for HMRC? Then secondly, the second thing I think that needs to be done is that there has to be a statutory public interest defense, so that the defense should be able to, if the defense can prove that a disclosure was in the public interest, then that should be a defense. The defendants should not be prosecuted, and any journalist reporting the matter should not be convicted if the disclosure and the reporting is in the public interest. And when we look at things like the amount of tax recovered, just talked about how whistleblowers help the authorities in the US to recover tax. If a disclosure that would ordinarily have breached taxpayer confidentiality led to the recovery of tax, clearly it shouldn't be in the public interest to prosecute the whistleblower or the journalist. So these are the two things I think we need to think about if you're in terms of how to protect whistleblowers and also journalists, and indeed any other citizen that want to exercise their right to know and to speak. Thank you very much.
Osita, thank you very much. I agree with you that yeah, I think you were clever in using the parliamentary privilege to allow you to speak. I assume that was what allowed you to talk to Parliament, is that there is, I guess, is that really what gave you the protection?
Well, that was one of the ones I had. I had other ones because the my so obviously that was dependent on the committee accepting my evidence formally. If they hadn't, I wouldn't have had that. So my ultimate protection was I had prepared a private prosecution of the HMRC official that did the deal. So I was prepared if I had insisted that they would prosecute me for disclosing what I believe to be a crime. I'll take my ability to bring a private prosecution to actually bring the crime itself to the public knowledge. So that was my main defense. But technically, the parliamentary privilege one was a very strong one because it's a complete defense.
When you were speaking, and I loved your suggestion of having a public interest defense, there's obviously strong parallels between what you're suggesting and the Official Secrets Act, right? When someone's trying to reveal national security information. So I keep thinking of Catherine Gunn, who is at the whistleblower at GCHQ.
Yes.
And so there's actually amendments as arising from her experience where she was charged with violation for revealing the information. But they ultimately dropped the charges against her ultimately. But I think there's been a big effort by a number of UK solicitors and QCs to try and amend the Official Secrets Act to create exactly what you're talking about. So I would think there'd be you could have synergies with that group. I think it would be great for you to be connected with them.
Yes. Actually, there was a report last year by the Law Commission where they made a proposal, but I think the government just rejected it. So yeah, I think that's one. Yeah, but again, they didn't look at tax information. They just looked at intelligence and security. Because when it comes to tax, we treat tax information as sacrosanct, but of course it has implications to, rights of whistleblowers and journalists and the public too.
In the United States, we have inspectors general that look over every agency, and you probably saw that with the Trump administration. And so you were talking about the ombudsman. Is there the equivalent there of a HMRC ombudsman who you could have gone to?
Well, there is the National Audit Office. I couldn't go to them because again, they're external to HMRC. In fact, I went to them, but when I went to them, what I did was, because you commit a crime when you disclose information about a specific taxpayer or information that can enable the identity of the taxpayer to be revealed. So when I went to them, I did not say which company it was, because that's when you can defense. So there's no defense for them. So they can't help. But again, you can't give information that names a taxpayer to them, even though they exercise some oversight over HMRC. There is absolutely no clear external route to disclosure, except the commissioners themselves. But at the time, as I said, the commissioners had delegated the power to the person that did the deal. So he was the only person at the time that could disclose anything externally.
Yeah, it's interesting. There's a bill circulating in Parliament in the UK at the moment proposing an office of the whistleblower, because the UK after Brexit doesn't have to follow the EU Whistleblowing Directive. There's a desire with this legislation not to be left behind. And it's really interesting because I think the office of the whistleblower concept, it would be another office of government, and it could kind of regulate the regulators. So I think that's something to watch. That may be another avenue. I am pleased to see that Khadijah has just joined us. Khadijah, are you able to hear us?
Yes, thank you so much. I do apologize for being so late.
You came in just in time. We needed to hear from you before we turn over to questions. So if you don't mind giving us about 10, 12 minutes of your thoughts. Khadijah, when I introduced you, I said we've heard from the journalist side, we've heard from the whistleblower side, and you straddle both, being at OCCRP as a journalist and then also having just finished up your term as director at PLOF. So we've built you up as someone who can tie both themes together for us. So I'm going to turn it over to you.
Thank you so much. I hope I don't disappoint anybody. So we've represented just over 24 whistleblowers at PLOF, and of course we work very closely with sources and whistleblowers at the Organized Crime and Corruption Reporting Project. What we see at a human level is that whistleblowers get frozen in time. They are distilled down to a body of evidence, and as the world celebrates them, you know, the Edward Snowdens, the Lux leaks, the Swiss leaks, Herr Falciani, in South Africa, Mosilo Motepu, it becomes a very hollow kind of celebration. It's predatory, even on the part of the journalists and the NGOs that are using them to build cases and campaign, and very often it cannibalizes them. So in almost 90% of the cases, these whistleblowers, although legally they won their cases or were vindicated, the reality is that they have no employment, they lose their families, psychologically and emotionally, they are wrecked and ruined. One of them right now is selling their home. So their lives become very, very difficult because they are distilled down in time, stagnating in identity, unable to move forward, and constantly forced to relive that evidence that they've disclosed. So they also end up being very alienated and the loneliest people in the world. And essentially, they're a last resort, disclosing what should have been in the public domain but wasn't, what was legal but wrong or against the purpose of the law, what harms the public good but is justified by those in power, for example, companies and governments, and of course, organized crime, perpetuating it as if it's in the public interest. And this particularly affects Africa because out of more than 50 countries, only I think 8 have a whistleblower law, a kind of a whistleblower law. And where they do exist, they aren't great. So in Namibia, for example, whistleblower law is passed, but no agency has been created. So you won't find Namibian whistleblowers coming forward. As in the case of fish rot, you'll find a foreign citizen coming forward about issues that are cross-border and impacted Namibian society. So of course, in these countries, even in countries with whistleblower laws, media becomes the obvious outlet, but journalists themselves across the continent are besieged and wrecked by slap lawsuits, threats, blackmails. Your editors might be too afraid to run content, or they may take away the substance of your story to avoid any legal pushback. We could take an example of Africa's best. South Africa, has a Protected Disclosure Act, but it lacks enforcement and punitive sanctions where any of these laws are transgressed. There's no dedicated whistleblower authority, and that means that the whistleblower is often at the mercy of other inadequate legislation like the Labor Act, or very exploitive lawyers who will lock them into a silo and use their information not for the public good, which is the reason why the whistleblowers came forward, but for settlements and for profit or for a class action lawsuit or something of that nature. And even where you do get a pro bono lawyer, the system is designed to contain disclosures due to that domino effect. So in the case of Habib Bank, for example, the head of auditing didn't want his name to be out in the public. He didn't want to be a hero and then be unemployed and have his family financially suffer. So he agreed to a settlement, which then came with a gag order. And we know from what happened with state capture that Habib was on the verge of playing a very critical role in the facilitation of illicit money. And the process itself was critical, but that process never came to light in the media because the whistleblower could see the repercussions of that. Another example is Mosilo Motepu. Before she came to PLOF, she had R1 million bill from a very big law firm that has made its name as a protected source, but they actually bankrupted her without taking her case forward through any kind of legal process. So whistleblowers don't necessarily know how to negotiate a legal landscape. And where it's pro bono, there was a case of an NGO in South Africa that was trying to get a whistleblower to perjure herself in order to create a campaign against a certain company. So even those with good intentions can force a whistleblower to put themselves in a bad situation that they at the time do not fully comprehend. We could go to a very bad example. In Swaziland right now, which is under a military lockdown, there are murders of protesters and citizens. There's frequent imprisonment and harassment of lawyers and activists and journalists. Big corporate companies are either propping up the dictatorship, the last absolute monarchy. Coca-Cola provides, I think, more than a quarter of GDP. The internet shutdown is facilitated by MTN, where the king has a share. So in Swaziland, although they have a semblance of a law, a whistleblower is called an impimpi, which means a snitch. And that's basically how, you know, they are framed, an informer. That's how they are framed around the continent, whether implicitly or explicitly. So that's why the platform for the protection of African whistleblowers was created, to provide a pro bono legal defense, the right security systems in transmitting information, acting as a liaison with the media, and also helping with advocacy and legislative rewrites, as in Nigeria. Because even where you get a good NGO or you get a good lawyer, their motives will put them in a silo that doesn't work for the public interest, which means this whistleblower has put themselves on the front line and has been sacrificed for society in ways that don't necessarily benefit society. So there was a need to create this, and the founder of the center had represented LuxLeaks, SwissLeaks, Edward Snowden, and a few others. So he understood the need for it in Africa, because many of his cases, his legal cases, involve the governments of Gabon and Equatorial Guinea, which are also dictatorships. And those whistleblowers just didn't have a way to come forward. So when we're looking at the issue of whistleblowing from an investigative journalism point of view, these people become absolutely crucial, and not just because of authoritarian or repressive systems, or even in Southern Africa, the dominant political parties that become parallel de facto governments because of all of the shareholdings through economic empowerment deals. You have, for example, on TI's Corruption Perception Index, you see African countries as the most corrupt, and a lot of tax havens as the least corrupt, the Netherlands, Luxembourg, Singapore. And these countries are the suppliers and the facilitators of opacity and secrecy that enable corruption at a vertical level from the top down. And when you see that culture in your country and you see 1 million people waiting in line and everyone struggling, that then helps facilitate a kind of horizontal corruption, because they see that the law and power enables inequity and injustice, and it happens in a way that they cannot challenge. So slowly people who are part of that system but don't really benefit from it start exploiting the only people they can exploit, which is the citizenry. And so that means that at a vertical and horizontal level, these political economies are captured through a kind of systemic inequality that is very hard to disrupt. So the only people who can disrupt it are those who have information as sources or whistleblowers from within the system. But because a whistleblower is a kind of juridical term, because where a law doesn't exist, you can't necessarily be a whistleblower because there's no process to go through. A lot of the times they end up being sources for media. So I should probably just stop there, but I'll end off with a few examples. In Botswana, you know, it seemed to be such a peaceable country. One dominant party shapes and kind of influences the landscape. And even though you never hear about Botswana in the news from the journalists that we've worked with, you're allowed to report on injustice, for example, involving cows, but not the president's cow. So you can't touch power in countries that appear to be peaceful and that appear to have decent governance and elections. If you do, Section 47 of the Penal Code allows for the Botswanan presidency to have exclusive authority in prohibiting any content, in imprisoning people, even if it's just a street vendor distributing information. In Rwanda, you know, under the dictatorship of Kagame, there's no designated agency to handle any complaints, and you can end up in prison for 7 years or more should you defame the president or his regime or any interest tied to him. We've had the heads of auditing departments at banks tell us that even where they find massive amounts of resource flows from the DRC through Rwanda involving South African interests, there's nothing they can do. Because the country and the political economy is entirely contained within a culture that has a lack of accountability for those who have power. In Zimbabwe, you see a lot of the old colonial systems are being used by the current regime. The Anti-Corruption Commission, you know, is the agency mandated to handle corruption and whistleblower claims, but it doesn't really have any power, and the country relies on common law, which says that anything that isn't explicitly prohibited is allowed. There's not even a proper definition of corruption. So there's no prosecution, there's no power to arrest. You can investigate, but the people who are part of that system, understaffed, underfunded, politically controlled, there's very little justice that can come from it. So we could go through each and every country, but at the end of the day, you find that the legislative system requires political accountability, which means that the citizenry, the fiscal social contract, must see the government reliant on citizen income taxes so that citizens have a way to hold their government to account. But the reason why most political economies are rent-seeking and that leads to authoritarianism is because they know they can have a selective democracy. They can get money and power from foreign companies, as Swaziland does Coca-Cola, as most of the Congo Basin does with the oil companies. And so they are only accountable to their so-called foreign investors. We've seen this in the Gambia. One of our whistleblowers was a key part of the system. He left the country before we published our investigation, the Great Gambia heist, over $1 billion stolen minimum by the Jammeh regime. Sorry for the howling. And we could basically see, let me just stop there. I think my dogs are barking. Thank you.
Thanks so much, Khadijah. One of the things I wanted to ask you about, and I'm hoping you're able to get your dogs contained, is that you've mentioned sort of the role that whistleblowers play in bringing information to journalists. There are a couple of organizations that have sprung up that seek to protect and actually train media organizations on how to deal responsibly with whistleblowers. So Blueprint for Free Press came up with something called the Perugia Principles to try and guide journalists to not unnecessarily expose whistleblowers. And then there's a new group called the Signals Network, a couple of years old now, that actually affirmatively their mission is to train journalists on how to deal responsibly. I was kind of curious about your reaction there and how OCCRP, do you follow the Perugia Principles? How does that work?
These are very good questions. The Signal Network is great. PLAF used to collaborate with Blueprint, and I think one of their people was on the board for a time. So I think it's really good that all of these civil society organizations have an integrated mission and complement each other rather than compete, because nobody wants to reinvent the wheel and everybody needs to focus on their own specific contributions. With the Organized Crime and Corruption Reporting Project, if a whistleblower does come to us with information, sometimes we decline to use that information if they will be in danger, because no story is worth endangering someone's life, their family, and long after the story is published, a mark will be on them forever, especially if you touch their money. And this is particularly the case with arms, with tobacco, and with drugs and wildlife poaching. These are not your usual corporate investigations where they may react in a way that is predatory or lethal, but legal. They'll take you to court and keep you there forever and bankrupt you, but they may not steal your wife and petrol bomb your house. So if we're dealing with subjects that have a very physical response that puts a person in danger, as with the Gambia or the wildlife poaching story, we try to remove that person well in advance and make sure that they're safe, that they have enough financial sustenance to keep going. Of course, we can't pay a source. And that's where we connect with other organizations that do perform this role. Where it's too dangerous, we advise them not to disclose. There was a story that we didn't run involving rhino poaching, and that source 2 years later was killed because another media decided to run the story. So that's one of the important things. And then I think the second thing is, as you go through the story, you have to look at signifiers and identifiers. Anything that could be, kind of pieced together to expose who is the source. When we did a story on Angola, we not only visited the relevant sources, but we created a false paper trail by visiting 20 other irrelevant sources, calling up 50 different people, so that if our documents and systems were ever taken into discovery, they would have so much. But the actual correspondence that's relevant would be under PGP, it would be under signal disappearing messages. So you want to create a false paper trail, try to eliminate or make invisible your source, try to distract people from identifying who actually provided that information. Because as a journalist, like a doctor, at the beginning and the end of the day, you can't help the public interest if you are harming the human being who forms part of that public and creating the wrong precedent for yourself, but also for the society in which you live. Nothing is worth harming that person. So we try to be as careful as possible, and the motto is first do no harm, and then remove all identifiers and signifiers from your story, even if it means you have to take out some evidence or corroborate it in a different way.
Thanks, Khadijah. I think that the trend is, I think the sophistication of journalists is rising in this level, but not soon enough, because as you were mentioning, it's trending in the right direction, but there's still a lot of education to be done. I now want to turn, we've only got 5 minutes left, and I want to get to some audience questions. So Josh, you are up. Naomi Fowler from Tax Justice Network has a question for you. She says, President Biden has committed to roll back the cuts over decades to the IRS and tax authority enforcement. Do you anticipate more successful enforcement, more cases as a result? And how would you like to see that increased investment targeted? So this is the $80 million, I think $80 billion that he's trying to earmark for IRS, trying to close the tax gap to pay for his many programs, including infrastructure. There's a lot of questions in there. I know you're not a federal employee or a state employee, but with those caveats, what do you have to say?
I would be so far out of my lane to speculate on that. I don't know, Mary. I almost think it's probably a better question for you.
I'm happy to take it.
Yeah, I mean, I only deal with the IRS whistleblower program in sort of an ancillary way, and have heard thoughts on all sides about it. But Mary, I think better for you.
I'm happy to take it, and so I think it will. If this money is actually comes through and is earmarked, it will be a game changer for the IRS, because the whistleblower office in the IRS currently, it takes 10 years for a whistleblower submission to get all the way through, and for a whistleblower to be told about whether the enforcement action took place and ultimately rewarded. So I think the program needs a lot in the way of resources, and actually just a commitment by the IRS to do more, because even though the statistics are great, they've made a lot of recoveries, and they're one of the biggest reward programs that's the most successful in terms of recovering lost taxes. They still don't process it nearly the close to the same rate as the SEC, and they just don't protect whistleblowers the same. So I think that $80 billion could go a long way. What's interesting, I think the most interesting development is Senator Elizabeth Warren, our former presidential candidate, is pushing for a key TAM mechanism, a False Claims Act mechanism for tax fraud. And the reason for that is that it follows the model that happens in Josh's office, that the whistleblower doesn't just throw the information in and then they're stuck with no role and it's up to the vagaries of the IRS. We can actually bring our private legal resources, the whistleblowers' resources forward to launch a case and try and actually be more of a public-private partnership. So I think that's a really interesting development. But yes, it's long overdue to have some more resources thrown at the IRS. And if it could be specifically to beef up the whistleblower office, then I think that program could really need a nice injection. All right, another question. Let's see, sorry. This one is from Adwitya Grover. What are the issues, and I think this is to anyone, what are the issues in implementing whistleblower protection in cross-jurisdictional cases? For instance, the Panama Papers, which revealed cases of tax evasion around the world. This is a really big question, because right now we're seeing the EU Whistleblowing Directive is finally going to have, the EU will have protections. We don't have a global protection. We're getting it. The United States is horrible. Our protections are very siloed. We don't even have an umbrella protection. It comes, we have it in we're very reactionary. First, after Enron, we did SOX protections. our whistleblower programs have protections, but I think even before we get to cross-jurisdictional, we have a long way to go even within countries to make sure that we even have an umbrella protection. So I do think that the model right now is the EU directive, and it was actually the inspiration for it was a whistleblower by the name of Antoine Deltour, who was a French national working in Luxembourg when he worked for PwC and showed the tax evasion issues there. And in France, where there's a whistleblower protection law, he would have been protected. In Luxembourg, he was being prosecuted. So the idea was we need to have a floor across all countries. So I think we're getting that cross-jurisdictional protection in Europe. I'd love to see it globally, and I'd love to see the United States actually have one that's no longer siloed, that's more global. But anyone else want to chat about that question?
I think Africa needs an anti-corruption court because very often you hit a ceiling in African countries. South Africa, of course, is very active around the African continent. And if your own judicial system is captured, there really isn't any other place to go. You could try to get asylum, but that will take years and years, and you have to qualify. So an African anti-corruption court, maybe even a global anti-corruption court, would allow for these issues to be investigated in a neutral forum where the whistleblower, the disclosure, the prosecution can happen outside of those politically contaminated systems. So where a whistleblower hits a ceiling in their own country, there will be the system. And it's happened in many other issues. You have the International Criminal Court, for better or worse, but you don't have an anti-corruption court. So hopefully that's something that happens. And you could pick any African country and you see the presence of many other African countries as corruptors or a foreign presence. In the United States, the Delaware Court of Chancery is one of the most corrupt systems you could ever find. And Delaware itself is a tax haven. So if we look at the vaccine apartheid that's happening everywhere in the world, those pharmaceutical companies are incorporated in Delaware because of the intangible asset perks and the secrecy. And if anything happens, they would have their case heard in the Court of Chancery, which is an old boys club. You have companies like Skadden Arp that charge exorbitant fees. Everything is very secretive. So there's no justice as long as tax havens and their judicial systems are active and provide these ring-fenced forms of secrecy. So in terms of cross-border equity, I really think we need to put a natural sanction on the use of tax havens or of jurisdictions that do provide legal and financial secrecy or confer that kind of legal privilege, because that kind of supplies the world with a system that protects wrongdoers and gives them more rights than innocent citizens and whistleblowers in the countries that are affected.
Thank you, Khadijah. That makes a lot of sense. I'm allowed to go over, and there's one more question. So I don't want to hold people too long, but I do want to get to Naomi's question. And I think it's a good one to end with because it's very broad. So maybe each of the panelists could tell us what they think about this question, which is, what are the things that would most support and protect whistleblowers and journalists? So for those of us on the whistleblower side, you can just talk about whistleblowers. For the journalist folks, you talk about journalists. I'm going to turn to you, Susan, since you started us off.
Thanks, Mary. I'm actually going to turn to the findings of our survey because the respondents, in responding to us, the investigative journalists around the world, they said that the most valuable thing while reporting on financial crime and corruption also overlapped with those that they identified as mostly lacking, which was legal aid and counsel, financial support, and whistleblower protections. So I think there's, we've spoken about it a lot, but I think there is this recognition of the relationship between the two. And also, I guess that they're often kind of out there on their own without a lot of protections. And to touch upon the funding point, I mean, a lot of the reasons why these legal threats work is because investigative journalists, especially how it works now, are at small organizations and they don't have the funding backing that, media would have had 20 years ago. So, getting legal threats is intimidating, even if you know what you've written is true, because even before you get to the court, getting legal advice, dealing with letters, responding, especially if it's in a jurisdiction that you're not familiar with, is expensive. So, of course, providing those things would be great. Having anti-SLAPP legislation, obviously the directive is already being formulated in the EU, hoping to see something similar here. Regulation of SNAP and legal intimidation enablers, which is law firms, but also reputation management companies that are largely unregulated. Yeah, basically stopping financial crime and corruption in the first place, because as you know, Khadijah also pointed out, a lot of these violations against journalists are happening or facilitated by political elites who are having their illicit wealth somewhere else, and that's bolstering their power domestically. So there's a real interplay between both sides of that.
I like your wish list because it's a good one. Excuse me, does anyone else want to take on the question of what are the things that would most support and protect whistleblowers and journalists? I feel like Susan took on journalists. Asita, Josh, either one of you want to take on the whistleblower piece?
Yes. I just make a couple of comments based on my I'll look at it from what I said before about the need for a public interest defense. It should not be a crime to disclose or report something that is in the public interest, particularly when it concerns crime. So if we look at the Swiss leaks, so under Swiss law, is a crime to disclose any banking information. So the entire tax evasion industry in Switzerland is based on Swiss law. Now, Switzerland is a signatory to the UN Convention Against Transnational Organized Crime, and that law clearly will breach their commitment there. Yet, when Falciani disclosed the information about Swiss bank, he was actually convicted of breaking the law, and the Swiss tried to indict him. Now, it was quite clear from all the countries that benefited from his disclosure, used it to recover tax revenue, that what he did was in the public interest. Yet, under Swiss law, he was a criminal. And all the journalists and the media that reported his story could be prosecuted under Swiss law as well. So, Khadijah talked about the international law on corruption, but there is the international law that already exists that are not being enforced. We need to ask the question, why should Switzerland be allowed to have this law that is used to facilitate international tax fraud? Yet there are signatories to the UN Convention Against Transnational Organized Crime and even the UN Convention Against Corruption. So there's a lot that needs to be done using the laws that exist to protect both whistleblowers and journalists. But it has to be based on the principle that it should not be a crime to disclose something that serves the public interest. And it shouldn't be a crime to disclose something that is a crime.
Asita, I think that's great. And as our one whistleblower on the panel, I think it's appropriate to give you the last word. So with that, I want to thank everyone for joining us. I really enjoyed the conversation, and thank you for letting me butt in with occasional editorial commentary. So thank you everyone for attending, and I know you'll enjoy the rest of the conference. I know we have coming up, I think Luke said we have a lecture coming up. So hopefully you're not late for that, and thank you everybody.